Hey guys, Jeff Goldtrap. Don't testify at your own preliminary hearing. First of all, we talked earlier today about not representing yourself, but especially don't testify at a preliminary hearing. There have been really rare occasions when people have testified in a preliminary hearing, but I've been practicing law about 23 years now, and I can count on one hand how many times it's been the right thing to do to testify in a preliminary hearing. Remember, the purpose of a preliminary hearing is only to find probable cause. Is it likely that a crime occurred? Is it likely that this is the individual? That is not proof beyond a reasonable doubt. So it's a very low level of proof. So at this point, how is it advantage to me? How is it going to improve my case for me to testify? Usually it's not. So if you testify, it's usually not to your advantage. Sometimes if you testify, it is certainly to the state's advantage, to the prosecutor's advantage. Okay, I have been in preliminary hearings where a person, not been in, I've watched preliminary hearings where the defendant insisted on testifying, and I watched one where they admitted to assaulting someone. Was in court not long ago, nearby here, and watched a preliminary hearing where someone insisted on testifying and they admitted to a burglary. Now think about that. You're charged with a misdemeanor, and while you're there and you insist on testifying, you give the elements or the needed parts to admit that you committed a C felony. Well, that can happen if you get so excited, so wrapped up, and so enthralled with your own case that you don't understand the implications, the consequences of the criminal rules of procedure, the criminal rules of evidence, and the statutes and laws. So, get yourself a lawyer. Don't testify in a preliminary hearing. I'm Jeff Goldtrap. If I can help you, let me know. Thanks.